By the end of this webinar, I hope, as I said, you get a lot more clarity about estate planning and understand the steps you need to take to complete your estate plan. Okay, my name is Martha Chang. I am a certified estate planner from the National Institute of Certified Estate Planners. I am author of the Estate Planning Decoded book, and I run a YouTube channel to break down estate planning concepts. Many of you actually met me there at my YouTube channel. So I'm thrilled tonight that I get to prove to you that I'm a real person, not an AI talking head. In the last 5 years, I lost my father and my mother-in-law. So this work is not just professional to me, it's also personal. All right, great. I am not an attorney. I will not be drafting your legal documents, but I will show you something even better that will be doing that. So we'll start with the 3 threats to your estate, okay? Because then you'll understand what, we'll start with something is blocking. Okay, great. So we'll start with 3 threats to your estate, to your legacy, and why a living trust is the answer to those threats. Then we'll go over the 4 steps to create a living trust. After that, you'll have a chance to decide if working with an estate plan partner, that's me, is your ticket to finally get your estate plan done quicker and more affordably. I'll make sure I leave time for Q&A. So if you have any questions, jot them down. Great. So many of us spend a lot of time, most of our lives building this legacy, this beautiful cake to hand over to the next generation, not realizing that there are several unwanted guests waiting with fork in hand, napkin ready to have a bite of the cake. If we don't plan properly when it gets to our children, you'll have a big chunk missing, or by the time it gets to the grandkids, only a slice is left, or God, forbid, only crumbs. Okay, so who is trying to take big bites of your cake? That's the first thing you need to understand. Let me tell you about Jayne Mansfield. So she was a very successful actress, and she died in a car accident without an estate plan. She was quite young. She was only 34. So the court stepped in. First, they split up her 4 children because they had 2 different fathers. Many of her friends said she would have wanted her mother to raise her 4 children together, but because she didn't have a plan, the court used the default plan. The house, when you're in probate, all your assets are frozen, so her children weren't even allowed back into their home. Even small sentimental items were locked down. Her daughter wanted this charm bracelet, sentimental value, and she was denied. She found out later that it was sold by the estate for nothing. It took 10 years for her probate to wrap up, and by the end of it, a little bit of money went to pay off her debts, but 90% of her assets went to probate court costs, attorney fees, appraisal fees, and her kids ended up with nothing. Stories like that doesn't just happen to celebrities. This recent Forbes article said that many families today are just unaware of the emotional toll of probate. On average, it takes 20 months. That's almost 2 years to wrap up probate. And all that time, your assets are frozen. The cost, about 3 to 7% is the average. So let's put real numbers. Let's say your estate is a nice round number, $1 million, and your probate went smoothly. No surprises, no family drama. So you ended up in the low end 3%. Well, 3% of $1 million is still $30,000. That's the best case scenario. That's money that should go to your spouse's retirement or your grandchild's college tuition, not to the courts. So that's the first threat to your legacy, the delays, emotional stress, and cost of probate. Threat number two is family fracture. Many of us know a family that's gone through this, and siblings that stop talking to each other after an inheritance, and we shake our head and we say, how sad. But to make sure this doesn't happen to our family, because I think family fracture is the biggest cost of a bad plan, to make sure it doesn't happen to your family, let's identify the three main causes of family fracture. The first is probate. Probate cracks families. For sure, stress, delays, fees put any family on the edge. And you add outsiders to that because probate is public, spouses, former partners, relatives get involved and they start whispering things like, oh, that doesn't seem fair. You did so much for your mom. Or if it were me, I would challenge it. And then you add, the coldness of how numbers, news is presented to you, the way courts, share information. Of course, all that puts a family on the edge. But what really makes it easy for family disputes to happen in probate versus outside the probate court is this. Probate provides a ready-made stage, a ready-made venue for conflicts. The judge is already there. A system for filing complaints is already built in, and attorneys are lined up. So all you need is just one objection, one disgruntled heir, and everything just escalates. That's a very common source of family fracture, being in probate. The family home is another big common source of family fracture. Do not treat it as any other asset because the family home is an emotional asset. It's not just a house, it's about Christmas mornings, it's about, cooking with mom in the kitchen. It's not just a brick, building. The house is also unequal. Perhaps one sibling has been living in the house. Perhaps one sibling has been staying in the house to take care of mom. It's also illiquid. You can't just divide, slice up a house into three. In my client's situation, he offered to buy out the house at a fair price from the other siblings. But one of the siblings said no, he wants to put it in the open market. He believes he would get more money putting it in the open market. Probably yes. But anyway, so they ended up selling the house. And siblings will swear that they still love each other, but that unguarded vibe, that joking, relaxed vibe is gone. So the family home is something you want to pay special attention to. Then there's surprises, okay? Mom told me this, but mom told me that. Last minute changes or surprise accounts. Surprises should be reserved for birthdays, not finding out, that your dad changed the will the last minute or there's unequal gifts. This actually happened with my family. And it's not that you can't do unequal distribution. It's when you don't tell anyone, it's the surprise. So we found out that my dad actually made a new will after the one that he shared with us. And that was a big surprise and would have caused a lot of resentment because everything went to my brother until it was explained to us that because most of us were abroad, it was much easier for my brother to settle the affairs and then do the distribution. So it's not the unequalness, it's not the last minute changes, it's surprises that fractures family. So that's threat number 2. What's threat number 3? What's your guess? First threat was probate. Second threat is family fracture. Very sad. What's the third threat? What would be your guess? When I asked this, most people guessed death taxes. That's what a lot of people are afraid of. Let's go through these death taxes that are scaring a lot of people. First is the estate tax. That's the tax that the estate pays the person who died. Of course, he's not alive to, write out a check, so it's taken out of his estate. So it's called the estate tax. Every tax has a federal component and a state level component. The federal estate tax is steep, okay? It's 40%. But fortunately, they're just targeting the ultra rich. The exemption is 15 million. If your assets are not over $15 million, you don't have to worry about the federal estate tax. If you're married, that's $30 million for the couple. But what about the state level estate tax? If you're unlucky enough to live in one of these states that I'm going to flash out on the screen, it's in alphabetical order so you can locate your state. If you live in one of these states, you will be imposed an estate level estate tax. However, if it's not highlighted, then the exemption is also pretty high, more than $3 million. If I highlighted it, then the exemption is under $3 million. Like my state, Massachusetts, is $2 million. So anything I own above $2 million will be imposed a state level estate tax. Fortunately, the state level estate tax is not 40%. It's not that high. In Massachusetts, it maxes at 16%. It's still not fun, but you can see that only 5 states are highlighted. 5 out of 50 states, that's 10%. So for 90% of states, it either has 0 state estate tax or the exemption is pretty high. That's your first death tax, the estate tax. The inheritance tax is the tax that is paid by the person inheriting the estate, okay? Fortunately, in the US, there's 0 federal estate tax, inheritance tax. I couldn't believe this when I first heard this. This means that if I inherit, $10 million from a rich uncle somewhere, I pay 0. Because I'm the one inheriting it, I pay 0%. If he has more than $15 million, he would be paying some estate taxes. But me as the person inheriting $10 million, I pay 0. That's the federal level. What about the state? Does your state impose an inheritance tax when you inherit money? Well, only 5 states have an inheritance tax. And if it's not highlighted, then direct heirs, like children, are waived. Only Nebraska and Pennsylvania do children, direct blood lineage, have to pay an inheritance tax. So that's going to affect very few of us. The third tax is the capital gains tax. In the US, I keep saying in the US because I've been doing a lot of travel, and in other countries, they don't even have some of these taxes. Well, in the US, if you make a profit on anything, your house appreciating, your stocks appreciating, your business, appreciating, any profit you make, the government wants a share of it. It's called the capital gains tax. Good news, really good news. The step up in cost basis rule says that when someone inherits an asset, its cost basis steps up, resets to the market value at the date of death. The key here is inherits. If your parents, 2 days before your parents pass away, give you their house, your parents will have to pay the a capital gains tax on the appreciation of that house. But if that house, if you inherit that house, meaning they pass away and you inherit it, you could sell it the next day and pay zero capital gains tax. Okay, so these are the three death taxes: estate tax, inheritance tax, and the capital gains tax. Let's see how it plays out with Mike, okay? Mike's dad passed away, and Mike inherited quite a big size portfolio. His dad's house, 1.2 million, that his dad had bought for nothing decades ago. Mike got his dad's IRA and Roth IRA, and his dad had a portfolio, had a brokerage account that was worth $900,000, some Apple and Nvidia stocks that he had bought for nothing. That's a big capital gains tax there. A life insurance policy worth $600,000, and a rental property that I'm sure he also bought for a lot less, right? So when Mike first found out what he was getting, his first thought wasn't, wow, I struck the lottery. His first thought was, I'm going to be hammered by taxes. So let's see how much taxes he has to pay. Because this is a huge sum to inherit, $4.5 million. Let's start with the estate tax. Did his dad have to pay any money taken out of his estate? No, because the federal exemption limit is $15 million. This isn't even a third of it. So zero federal estate tax. What about the state estate tax? Florida was not on the list. Florida has zero estate tax. Now let's talk about the inheritance tax. The inheritance tax will be tax that Mike has to pay. In the US, it's 0% inheritance tax on the federal level. At the state level, Florida also has no inheritance tax. Remember, only two states, Nebraska and Pennsylvania, imposes an inheritance tax on children. If you live in any of the 48 other states, zero. What about the capital gains tax? Look at all these profits, appreciation that his dad's assets. Yep, you've been paying attention, so you remember the step up in cost basis. All these assets just simply get a new cost basis. That's the market value of these assets at his dad's death. So Mike could literally sell the house, sell the rental property, cash out all the brokerage firms, brokerage accounts, and pay zero capital gains tax. Do you still think that taxes is a threat? For a lot of people, it's a phantom threat. Very few people will get hit by taxes. So the threat number 3 is not taxes. It's inheritance, wealth erosion. What do I mean by wealth erosion? Here's what I mean. Suppose your estate dodged probate, okay? Good job. Suppose it dodged a family fracture. Wonderful. And suppose it dodged the taxes, because it didn't take a lot of effort to dodge those taxes. And now your estate made it intact to your heirs, whether it's your children or your nieces or nephews or your siblings. A new set of risks show up when your inheritance make it to your heirs. Have you heard of the lottery winner's curse? Lottery winners, a lot of them lose their winnings within a few short years. Some of them even are worse off before they win the lottery because too much money too quickly without guardrails makes us do stupid things. Okay? That can happen to your heirs if you're not careful. Or they may be very responsible heirs that feel pressure to keep your estate growing. So they get into high-risk ventures that they don't know much about, and they get scammed or they lose the inheritance. Are your heirs in a high-risk profession like a doctor, surgeon, lawyer, or a business where lawsuits, where they can get sued because, they live in America? Then if you give your inheritance outright to them, that becomes exposed to these lawsuits and creditors. Okay? Potential divorce. I heard the story where, okay, inheritance, sorry, let's step back. Inheritance is considered separate property, not a marital property. But the reality is that when you've been married a long time, a while, it's so easy to get the inheritance commingled. In the case of the story that I heard, this young man donated a part of his inheritance to a charity, and he put his wife's name as part of the donation, right? Nice guy. Well, years later in the divorce, the wife's attorney claimed that one act, because the inheritance donation was made from the couple, that one act commingled his inheritance. So when they divorced, half of that inheritance walked out with the ex-spouse. It's very easy to get the inheritance commingled. And if there's a divorce, then half of it walks out. Or how about an heir who passes away before he could make his own estate plan? Then probate steps in for that heir, and his inheritance will go to the next of kin, which is his wife. If his wife remarries, then that inheritance essentially has left the bloodline. These are dangers to our heirs' inheritance. This is what I mean when I say wealth erosion, because these things do happen if you don't set up protective safeguards. This is why this 20-year research on 3,200 families, this is why the data shows that by the second generation, only 30% of that inheritance is left. And by the third generation, it's 10%. So now, if you remember when I used the analogy of a whole cake, being left into a slice or crumbs, I'm not exaggerating. Is this the path that you want your inheritance to flow? There are some smart families are able to make their inheritance last longer. They call it whatever generational wealth, dynasty trust. Let me show you how the charts would look different. So instead of the wealth being eroded to 30%, 10%, families who plan properly could slow down that erosion. I'm just throwing hypothetical numbers, but maybe by the third generation, you still have a third of the inheritance. Or families who strategize, not only do the inheritance not erode, it grows. You see this with the Waltons. You hear this about ultra-rich family who plan well. A lot of these tools are now accessible, available to mainstream families. Let me get a sip of water. So you are not, you are not, your inheritance doesn't just have one path to go. If I told you that you could do one simple thing to increase the likelihood of your inheritance going in the right direction, eroding more slowly, staying more intact. If you could do just one thing to increase that likelihood, would you do it? I think a lot of you would say yes. Well, that one thing for a lot of families is a living trust. For most families, a living trust will protect them against probate, keep the family whole, and preserve your children's inheritance. Now we are in the part of the agenda where I show you how a living trust does that, because you shouldn't just take my word for it. You should try to understand how a living trust does that. Let's start with the first one, okay? How does a living trust protect us against probate? We hear it all the time. Oh, do a trust, then you'll skip probate. Do a trust. But how does it do that? To help you understand that, you need to first understand the flip side of probate that no one talks about, the good intentions of probate. All you hear is the bad things about probate, right? It does have a bad reputation. Now I'm going to show you the good intentions of probate that you probably never heard about. When we die with assets still in our name, that's a big problem because you want these assets to transfer to your heirs, but who's going to sign off on the titles of these assets? I'll be 6 feet under. I can't sign off on the title. So the courts step in to protect us. What is the court trying to protect? The court is protecting our assets. So the court requires that our assets be inventoried. They require appraisal, so we know what our assets are worth. The court is trying to protect our wishes. If we had a will, was it authentic? Is it really our wishes? Or were we pressured? Were we unduly influenced? Or, God forbid, is it a fraud? Did someone unscrupulous modify our will? The court wants to make sure of that because they want to protect our wishes. The court wants to protect our heirs to make sure that the titles of our assets transfer to the right heirs. This is the court's intention. Unfortunately, how it plays out is usually a nightmare, as you've seen in Jayne Mansfield's case. It's slow, it's stressful, and it's expensive. You need to get appraisals, you need to get, attorneys, you need to do court fees and all that. But now you know that the courts actually have a good intention. This is what probate is all about. It's because we die with assets still in our name. Now that you understand this, you also understand that the way to get out of probate is by removing assets, titles from our name. We put it in the trust. So we are no longer the owners. We are just trustees. So when we die, there are no assets still in our name for the courts to protect. There's no need for probate. We took care of our assets. Thank you very much, Judge. You don't need to protect my assets or my wishes. Everything's been taken care of. It's in the trust. I don't own anything. I'm just a trustee. So when we die, but while we're alive, as trustee, we still have full control of our assets. We live in our house. We can even sell our house if we change our mind, or we can sell it, or we can refinance our house. We can buy new stocks. We can sell new stocks. As trustee, we have full control of our assets while we're alive. But if we get incapacitated or if we die, then our successor trustee steps in and follows the directions of the trust. No court involvement. You will also understand, now that you know what probate is all about, that a will does not avoid probate. Why? Because a will is essentially a letter to the judge. The assets are still titled in your name. Okay, now a good analogy would be, let's say, remember when you bought your house? Would you have been okay if the seller wrote you a letter saying, thank you so much for paying me, gazillion dollars for the house. Here's a letter saying that I gladly give you my house. No way, right? You get together in a room with your attorneys, the other party's attorneys, to make sure he signs off on this title. The problem, of course, is that with a will, we're no longer around. The title is still in our name, so the courts have to supervise. So a will is a ticket to probate. It's not enough. That's how a trust avoids probate, okay? How does a trust reduce family fracture? Remember the three sources of family fracture, okay? One is probate. So a trust avoids family fracture just simply by avoiding probate. And the process of creating a trust itself, makes you plan more intentionally, makes you think about family dynamics more, how will this child feel and so on and so that the process itself encourages you to do more intentional planning. And of course, writing it down, having a trust document just provides more clarity and reduce surprises. All right. What was the third threat that a trust is supposed to avoid? It's not taxes because you don't, there's not much you need to do to avoid taxes. It is how to prevent erosion. Erosion, whether it's your children as heirs or your siblings or your nieces and nephews. With a trust, you can specify, you can stagger the inheritance. You can't do that with a will. With a will or with a beneficiary designation, let's say your brokerage account, there is a simple way to avoid probate just by listing your heir as the designated beneficiary of your brokerage account. Then when we die, the brokerage account simply goes to the beneficiary designation. But guess what? It's distributed in one big lump sum. They literally get a check from the institution, a big check that says, here is the entire sum of your, dad's, your uncle, your whatever brokerage account, all yours. Again, too much money too quickly without guardrails is is trouble. So with a trust, you can stagger. You can say, I want a quarter to go to my children when they turn 30, and the rest when they turn 35 or 45, totally up to you. Not only that, you also get to assign a trustee for the trust until that age. Because just because the children are not of the distribution age yet, doesn't mean that they don't get help from the trust funds if needed. The IRS recognizes that even before they reach this milestone age, anytime they have a need for health, education, maintenance, and support, the trustee can distribute the funds to them. Okay, so I think this is the best of both worlds because they have access to the funds, but they're not the outright owners. So if they are in a lawsuit, in a divorce, in a bankruptcy, the creditors cannot touch the trust because it doesn't belong to them. You can't sue me for something that I don't own. So this is how a trust has a better likelihood of your wealth not being eroded by those dangers that we went through. Okay. All right. Now we're at the about to go into the section of how to create your trust. It can be intimidating if it's your first time, but understand that, but I'm going to present it, but they're really just 4 steps. By the way, of course, feel free to take, whatever notes of big aha that you're getting, but I will also be sending a replay of this webinar in a day or two to you. So you will have this webinar as well. So the 4 steps to creating a trust. Think of it as building your house, okay? The first step is deciding on, key parameters before you even hammer the first nail. For the second step is deciding on the team that's going to build this house for you. You want experience, you want skill, all that. And the third step is getting your house inspected, making sure that it's safe. I call that validating the house. And the fourth step is moving into the house, right? Now you may think, Martha, if I build a house, of course, it's so that I can move in and enjoy its safety, security, and comfort. Well, you'll be surprised how many people spend money creating a trust and then they leave it empty. They don't transfer their assets, their house, their rental property, their businesses into the safety of the trust, so they still end up in probate. Don't blame the trust. It's because these assets were transferred in. Okay, so these are the 4 steps. It's like, think of it as building a house and moving in. Let's now drill down into each of these steps. What are the key decisions you need to make when you start on the trust, on creating a trust? Okay, let me just show you. This is not an exhaustive list. We don't have time. I could give you a checklist, but for now, I'm just going to show you the big decisions you need to make. Okay, if you're married, when the first spouse dies, do you want everything to go to the surviving spouse, the second spouse, or do you want to split up the assets into 2 trusts, one for the surviving spouse and one trust for the deceased spouse? I see this with blended families more often because this ensures that the assets of the deceased spouse can be protected for his biological children. Because in the first option, but if everything goes to the surviving spouse, she could remarry and redirect 100% of the assets, or she could be in a lawsuit and all the asset is exposed. She could even dissolve the trust because it's a revocable living trust. So I see the second option more with blended families. Another example of a decision you need to make is distribution to your heirs, okay? What age are you ready for your heirs to get their inheritance? This is if you have children, but also if you're inheriting it to nieces, nephews, what age do you want them to get the inheritance? Do you want them to be trustee of their own trust until before the distribution age? It's a trust, right? It's the money stays safe in a trust. Do you want them to manage? Do you trust them to manage their own trust? Then third decision is, do you allow them to, let's say they don't need this money to spend on themselves, health, education, maintenance, support, their needs are taken care of. Do you allow them to direct the assets in the trust to just anybody, or stay in the bloodline to just their children, their siblings? Or do you allow them to direct it to their spouse? A lot of families say, no, I want it to stay in the bloodline. So if the spouse pressures them or manipulates them, they just can't. They can just simply say, I'm sorry, the rule says I have to stay within the bloodline. Another batch of decisions you need to make is your successor roles. Who's going to be your healthcare proxy? Who's going to be your power of attorney if you're incapacitated? Who's going to be making those financial decisions for you? If you have minor children, the guardian. Who's going to be your executor for the will or the trustee of the trust? Now, when I say will here, it's not the same independent, standalone will. With a trust, this will is called a pour-over will. It's a much simpler will, and all it says to the judge is, hey, if I forget to transfer anything into the trust, just pour it over into the trust. That's my intention. Okay, you'll still end up in probate, but it would be a much quicker probate because the pour-over will has set your intention. Ideally, it's a safety net that you do not have to resort to because you remember to transfer all your assets into the trust. So step number 2 is on choosing a platform. You're not going to use AI to draft this, okay? You are not going to try to do it yourself. If you don't want to work with an attorney, there are a lot of powerful online planning platforms, but let me show you that there are 3 categories. When you evaluate these platforms, understand that there are 3 categories. Okay, let me move here now. The first category is general legal platforms. These are platforms that also do your apartment leases, your purchase and sale contracts, and business incorporation documents, and estate planning. I tend to stay away from these general legal platforms because they're not dedicated to estate planning, which is what the second category is. These platforms were created from the get-go as dedicated estate planning platforms. They don't do anything else. They don't do apartment leases and so on. So Trust and Will, Nolo Quicken. So I find that they can handle more nuanced situations. The third category is, let me move back here. The third category are platforms that were created from the start to work with financial planners, estate planning planners, and their clients. These platforms, you cannot sign up directly. You have to be invited by your advisor, whether it's a financial planner or an estate planning partner. So these platforms tend to be more sophisticated because clients who work with advisors tend to have more complex portfolios, tend to have more nuanced family situation. So these platforms tend to handle much more nuanced, much more sophisticated, have more sophisticated features as opposed to the second category where that was created for mainstream families. Okay. So just when you evaluate platform, just understand there are three categories and where the one you're evaluating is which category. Whichever platform you evaluate, these are the key features you want to look for. Not surprising, easy to use, but flexible and powerful. You want to make sure it's attorney drafted, not AI or just some paralegals. You want to make sure it's tailored to each specific state because every state has different requirements. Live chat, telephone support is very important because for most of you, this is your first trust. And estate planning is complicated. You want to be able to pick up the phone and call someone, not just have to resort to reading pages and pages of manuals. Audit checks, summary reports, that's very important as well. So you can see your key decisions at a glance. And for sure, security is important because you're putting in some, confidential information. Examples of what that looks like, okay? So for example, the platform has to be easy, a question-based kind of platform where you're just answering questions, choosing an age of distribution, for example, for your heirs, or deciding if you don't want the trust to terminate until your heirs pass away. These are some summary reports that can help you review your estate plan more regularly because you can see your key decisions at a glance. The reason a lot of estate plans don't get reviewed for years and years is because nobody wants to read like 30, 40 pages of legalese in a trust document. They feel intimidated, they don't understand it, they say like, what's the point? But when you have a quick summary to review, you can easily, like I found out one of my trustee had actually moved abroad, when I review it. So it jogged my memory to, I need to find a new trustee. It just makes it a lot easier to review your trust. And make sure the platform gives you a signature checklist of where to sign the document, whether it needs witnesses, whether it needs a notary. And this step, signing, witnessing, notarizing your document, should be called out as a separate step because when a lot of DIY trusts fail, it's because it wasn't signed properly, it wasn't notarized per the state's requirements. So this warrants its own step. It's very important that you follow the signature checklist. In fact, I tell my clients before they even go to the notary public to tag all the pages that need signatures, witnesses, and notary. So you're not at the notary public flipping through 30 pages of your trust. That's a good way to miss them. By the way, I don't know about your state, but in my state, Bank of America, a lot of banks do notaries for free. So you don't have to pay for, don't go to an attorney to get something notarized. That's like a waste of money. And the fourth step, funding the trust, is to make sure that you've transferred your assets into the trust so that when you pass away, the assets aren't still in your name. Now, I have a video that talks about what assets to transfer in your trust because not all assets belong into a trust. I don't have the time to go through that list right now, but that's a worthwhile video to watch. At any rate, this is such an important step. An empty trust is a worthless trust. In fact, you just spend your money creating the trust for nothing. You'll still end up in probate. Okay, great. So those are the 4 steps of creating a trust. Let's summarize what we've gone through, okay? Because I have just shared a lot of information. You may feel overwhelmed. So just a quick summary here. We talked about the 3 big threats to your legacy. It's not the death taxes like most people think. It's probate, it's family fracture, it's erosion. Then we talked about why a living trust and why a living trust counters those threats by putting titles in the trust, by distribution ages, and what you can do to avoid family fractures. And then we talk about 4 steps to creating your living trust. That's what we've covered the last 45 minutes. Congratulations, because now my guess is that you know way more about estate planning than 90% of your friends. But here's the thing. I don't think you're here for more information. I think you're here because this has been on your mind, on your plate, you really finally just want to get it done. Well, if you don't want to hire an attorney, you traditionally have 2 choices. One is a do-it-yourself, totally, because the internet is full of information and how-tos, but you'll be doing it alone. You will be spending a lot of time doing research, weighing trade-offs, and after all that, you'll still feel a bit uncertain and a bit confused because there's no expert to really, double check your best guesses. The second choice, there are also online courses that you can pay that will promise to show you step by step how to do your trust. It seems easy to start, but it's also easy to stall. It seems great on theory to watch the videos on how to do it step by step, but when you actually do it and you're stuck, there's no one to ask. And oftentimes you have to pay additional expense to buy to sign up on the software to create the estate plan. If the online course includes the software, it's usually very basic and generic. So the lack of one-on-one support is why online courses seems like a great idea, but the data shows that the completion rate is pretty low. So today I want to show you a third option, which is working with an estate plan partner. And our program will help you complete your estate plan documents in 3 one-on-one advisor meetings. Okay, how does this program really work? This program has 3 components. The brain is the engine, is the wealth.com platform. I'm not exaggerating when I say that it is the Ferrari of estate planning tech. It creates attorney quality documents tailored to your state in a platform process that's easy to navigate through, that's question-based. And you have a certified estate planner, that's the other component, to be your one-on-one guide for any questions. The result is a complete estate plan. Let's drill down further to each of these components, okay? The partner, I'll be working with you as the estate plan partner. We will start with a one-on-one onboarding meeting. By the end of this onboarding meeting, you will have a draft of your living trust. We'll have an additional meeting to review your final documents. The reason we don't finalize your documents in the first meeting, even though we could, is because estate planning is like Texas barbecue. I was just in Texas, so the memory is still very fresh. it doesn't take a long time to marinate, to rub the barbecue meats, but I heard that it takes 18 hours, maybe 2 days, to turn it into that legendary Texas barbecue that I had the good fortune to experience. And estate planning is like that. Going through the wealth.com platform to specify your preferences actually takes less than an hour. But you want to give yourself a couple of weeks to talk it over with your spouse, with your family members, really think through the decisions that you made, the choices that you make. You really want to ruminate and mull things over. So when you've completed and finalized those documents, we have another one-on-one review meeting in case you have questions. And then when you have the document signed, we have another meeting to train you on funding your trust, because this is a very important process. And every step of the way, checklists, shortcuts, resources, any of these that I have is made available to you to shortcut your process. Example, you don't have to go researching online how to choose power of attorney. I will give you a checklist on how to choose a good power of attorney. That's the first component. The wealth.com, as I said, is the platform. It's invitation only. Feel free to go to wealth.com to check out the platform. You won't be able to sign up because it's invitation only, but you'll get a sense of the team behind the wealth.com platform, the team that's backing it up financially, Google Ventures, City Ventures, but also the attorney team that's behind it. You will have unlimited plan edits for 6 months. No other platforms offer 6 months. The other platforms only offers 30 days. And the wealth.com platform has live chat, phone, email to support you. Okay, so that's the second component. The third component, the result, is that you get your complete estate plan documents. That includes the revocable living trust, the pour-over will, the healthcare proxy, and the power of attorney. If you already have a healthcare proxy or the power of attorney, then the focus will be on the revocable living trust and the pour-over will. Those are the two the core of your estate plan. The other two documents are pretty simple to create. So that is the estate plan partner program we have. The big difference at the end of the day is that you're making real progress. A draft of your living trust by the end of your first session, for example, you're not just continually learning more and getting more and more information overload, but never actually getting to the finish line. Okay, let's talk about costs, because cost is real. When I talk to a lot of people why they haven't done their plan, it's not because they don't think it's important. They know how important it is. A lot of them have research on estate plan attorneys. They've picked up the phone and talked to an estate plan attorney. Some even go for that, free consult. And then they get the costs of creating an estate plan. They get a sticker shock, and then they just, drop the ball. So I want to acknowledge that cost is a big thing. One of the big reasons why 2/3 of Americans do not have a plan. For sure, don't just do nothing. You've seen the cost of probate. Attorneys, if you've called attorneys, to get a full plan, depending on where you live, this is the ballpark. Do it yourself is not free because it requires you to pay for the software. Okay, so these are the cost options out there. The estate plan partner, these three components. What do you think is a reasonable value for getting a premium platform with one-on-one support that gets you the results of your estate plan document? What would be a reasonable value for such a service? You can put it in a chat, or you can on mic and shout it out while I take a sip of water. No volunteers? Well, with many of my clients, after they see the high quality of the estate plan documents, and they experience the one-on-one support and how much they've grown. Because this plan is the best of both worlds. You get a guide, but at the same time, you grow so much in your knowledge of estate planning. My clients who've been through that, they will tell you that it is worth what an estate plan attorney charges. But I'm charging way less than that. For a couple to do a plan with me, it's $795. For a single person, if you're not married, you just need a plan for an individual plan, it's $695. And I am I can do better for my webinar attendees. I'm taking off $200 off the plan if you take action by Monday midnight. Today is Thursday evening. If you take action by Monday, that gives you the weekend. Now, I am very generous with sharing a lot of my information, my resources, my ebook. So you may wonder, this is out of character. Why give us a deadline? Why give us a deadline? If you really want to give us a discount, just give us a discount. Here's the honest answer, okay? Why not? My hunch is that you're not here for more information. You have spent a lot of time watching YouTube videos, reading up a lot of material, weighing options. And tonight you've invested an hour, a precious hour of your time to go through this webinar, not to get more information. It's because you're finally ready to take action. So why not take action? Why not take action today, tomorrow, this weekend, by Monday? This is an email I received from my client that I started working with in December. And when I read what her email said, I received this in January, a couple of weeks ago. It said, my husband passed away. I just held my breath because we hadn't done the final wrap off. Fortunately, and I started breathing again when I read that, fortunately, before her husband passed away, they had signed and notarized and completed and funded the living trust. She came so close. Here's another email from a client who said, I completed my plan, but what I want to highlight is this last sentence. Thank you for lighting the fire under me. That is the reason I have a deadline. It is my job. It is my job to nudge you to the finish line because you're so close. You're so much closer to the finish line than you yourself believe. So after the $200 discount, it is for a couple, it's $595. For a single, it's $495. On top of that, to incentivize you further to take action, I have 3 free bonuses for you. The first bonus is this estate plan checklist ebook. It's 53 pages. I get the same questions over and over again from my clients. How do I choose a power of attorney? What criteria makes a good, as trustee? How do I share my estate plan with my family? So I put all that into this ebook, and you will be getting it as a free bonus. Bonus number 2 is lifetime unlimited edits. All other platforms give you 30 days. And I'm thinking, that's not enough time for a Texas barbecue to really marinate to what you really want to be sure about. So I gave you 6 months, but this bonus extended to lifetime unlimited edits. You don't have to call up your attorney anytime something changes and worry about what your attorney is going to charge you for this change. You simply log back to the platform and make the change. Bonus number 3 is the favorite. It is a complimentary wealth.com account to anyone you want. Your neighbor, your friend, your relative who still thinks that a will is all you need to avoid probate. To your parents, if they haven't created their estate plan. So a complimentary wealth.com account and all the resources, worksheets, scripts, templates, bonus number 1 and bonus number 2. I will not be doing an onboarding meeting with them or a review one-on-one meeting with them, but by that time, you will be able to help them. And this bonus is contingent on your completing your own estate plans. I don't want you to get excited helping someone and get distracted from your own plans. After you completed your own estate plan, you get this third bonus. You can give a wealth.com account to anyone you want. So when you go to estateplanpartner.com to sign up on this program, this is the screen you will see. I just want to let you know what to expect. You will choose whether you're doing an individual plan or a couple plan. After you choose the appropriate button, you will get this payment page. Don't forget to enter the promo code for the $200 discount. The code is TRUST200, and you want to enter it into the payment page so that the price gets cut by $200. And after you've done that, you will get a scheduling page to book a one-on-one time with me. I am currently fully booked through the end of February, so I think the first available appointment would be either end of February or early March. All right, so let me summarize what you're getting here. For the price of $495 for a single, $595 for a couple, if you enter that promo code by Monday, you get one-on-one support, you get the wealth.com platform, unlimited edits, lifetime, and you get your complete estate plan documents. The 3 bonuses you're getting is one is a checklist, the 53-page checklist ebook, lifetime unlimited edits, and this third bonus, only after you've completed your own plan. It's a wealth.com +1 subscription, also lifetime, that you can give to someone really it's time that they do their plan. That is a lot of information that I just barraged you with. Now that's the end of my presentation. We are open for questions. Feel free to type in your questions in the chat, or just unmic yourself and speak up. If you ask me a question right now and speak up, you go first. It can be any question about any of the things I mentioned the last hour, or something I haven't mentioned.
Can I butt in?
Yes. Hi,
Sure.
Rich.
Hi. So that was great presentation. I did have a couple of questions, and one was, how do you do it when you have property in multiple states? Do you do separate trusts?
No, actually, that is the wonderful thing about a living trust. All you have to do is to transfer the deeds into one trust. If you don't have a trust, you would be probated in each of those states. So for someone like you with properties in multiple states, you have even way more reason to do a trust. But with one trust, you just do a living trust where you live, and then you transfer the deeds of all those separate properties into the trust.
Well, the reason I was asking was because one of the properties is in California, and I thought or understood maybe that certain rules are different for California than they are.
I'm so glad you mentioned that, Rich. So think of it as 2 steps, okay? The first step is finalizing. The first step is creating and finalizing your trust document. That does not involve any transfer of titles. You're just focused on getting your living trust signed, witnessed, notarized, and when you finalize it, you get a certification of trust. The second step is transferring titles into the trust. And if one of your properties in California does have special rules. If you are not careful, the property could get reassessed and then your heirs would be paying much higher real estate taxes. So maybe with a property in California, you get a professional title company to do the transfer. You provide the certification of trust to that professional title company and say, I need to transfer this property into this trust. And they will know all the California rules to avoid all those trap falls for California.
Okay, great. Could I ask another question?
Sure.
What about successor trustees? Say your heirs that you designated in the trust maybe don't survive. How do you specify trustees beyond that limit, or do you?
So give me an example. You said your heirs don't survive,
Yeah,
meaning,
suppose I have one of my heirs as a trustee, or what do they call that? A successor trustee?
yes.
Suppose the successor trustee dies.
Okay,
Who's
got
the
it. I
trustee then?
understand.
I mean, how do I designate?
Yeah, I understand your question now. And it's actually not common. Another way of asking this is, I have a small family. I don't have children to assign as a successor trustee. I don't have siblings either. What do I do? Who should I make successor trustee? So you have several options. If you don't have a relative or a trusted friend, a neighbor, long time, lifetime best friend to make the successor trustee, then you would have to resort to what they call a professional trustee. And there are two different types of professional successor trustees. One would be a company such as Vanguard. I like Vanguard. They have a trust company. Many people just think of them as an investment company, but they actually have a trust department that will manage your trusts. They will assume the successor trustee roles, meaning they will distribute, they will follow the trust rules if they need to distribute money to the heirs. They will file the trust tax return, and they charge 0.25% of your investment. Unlike a professional trustee company that charges normally 0.5% to 1%.
Yeah, great. Thanks.
Okay. Elaine, if you're still there and there's any questions in the chat, could you read them out?
Yes, there's a question from local. He says, we already have all bank accounts.
Sorry, could you be a little louder?
Can you hear me?
Yes.
Okay. So the question here is, we already have all bank accounts, IRAs, stocks, etc., titled as payable on death with beneficiaries. So don't these bypass the probate, trust, etc.? And doesn't beneficiary take death certificates to banks and claim the funds? Or do they still have to be listed in the living trust?
That's a great question because
So too.
yes, that is a great question. A trust is not the only way to avoid probate. If you designate specific beneficiaries on things that allow them, you would skip probate. Some states even allow a transfer on death deed on houses. So you can designate a beneficiary on the transfer on death deed of your house. So you don't even have to transfer title. You don't have to create a living trust. When you pass away, it goes to the person you designate as a beneficiary. I have a video on that. I always ask you to exercise caution. It works best if you only have one heir. If you have multiple heirs and they can't agree on what to do with the house, you usually end up in court. So yes, there are other ways to avoid probate. Now, a trust doesn't just avoid probate. If you remember my slide, a trust can avoid probate and also avoid wealth erosion. The thing with designated beneficiaries is that all the assets is given out to you in one lump sum. And if your heirs are mature enough, prepared enough to handle your entire, IRA distribution in one lump sum, then you don't need to stagger it. You don't need a trust to protect it from their creditors if they're in high risk professions. If you don't need that protection, also, if you feel that you don't need a trust to avoid family fracture, that you're because beneficiary designation, you have to specify it for every estate. If you have 3 brokerage accounts, 2 IRAs, this and that, that's multiple places. A trust can pull it together and distribute it more equally. So if you're not worried about family fracture, you're not worried about protecting against wealth erosion, you're not worried about irresponsible heirs, you're not worried about probate because you can do all this beneficiary designation, then no, you don't need a trust. Any other questions in the chat? That was a lot of information, guys. Either you've been watching all my videos, so you are fully educated, and today was just a refresher, so nothing confuse you.
Excuse me,
Or
Martha.
yes.
There is one more question from David. He says, do we sign up for your program simply by logging on to wealth.com and using the code?
Oh, no, you go to estateplanpartner.com. That's where you sign up. And when you do that, you will get this screen on the left. So you can choose, David, if you want to do a single plan, a plan for a single person or a plan for a couple. So it's estateplanpartner.com. After you go through this process and set up a one-on-one Zoom meeting with me, then I will send you the invitation to sign up on wealth.com.
Okay.
Okay.
My wife passed away in December, and so I'm just having, and her estate, went to me, so that's all taken care of. But I'm trying to set things up now for, the children and so forth.
Do you have additional questions?
No, I don't think so.
Okay. Well, I'm really sorry to hear about your wife, but you just brought up that there is a third way to avoid probate. It is joint ownership with rights of survivorship. So when I die, if my husband is a joint owner with rights of survivorship, everything goes to him. That's what rights of survivorship means. Everything goes to him, bypassing probate. But of course, as David pointed out, now he has to do an estate plan because you don't want to put your children as joint owners with rights of survivorship on your estate, okay? That is a big no-no. 2 big reasons. When you do that, they are owners of your estate, and that asset is liable to all their liability risk. They're in a car accident, the third party could sue your house because they are a joint owner of your house. That's the first reason, okay? You don't want to expose your assets to their liability risk. The second reason is that you don't get a step up in cost basis. Remember, if I pass my house to my kids when I'm alive, I have to pay the capital gains tax. But if the house goes to them, when I pass away, the cost basis steps up.
Martha?
Yes?
There is another question. What about home protection if you have to go into a nursing home?
In America, if you have to go into a nursing home, and the government will pay for your nursing home if you meet the Medicare cutoff. So that's out of my lane. My lane is solely educating, clarifying, supporting someone to create their estate plan. Medicaid is a whole different, different beast because you're talking about how to hide your assets so that in the government's eyes, you have less than $2,000 in assets. I think that's such an impossible cutoff. You would have to hide your assets in life insurance trust, irrevocable trust. And when you hear the word irrevocable, just know that it means you no longer control it. It's not like a revocable trust where you can swap out assets, sell, refinance. If you try to hide your assets in an irrevocable trust, or some Asian parents will, give their assets away to their kids early, so it looks like they're stricken, they're poor, dirt poor, then you lose control of your assets. So number one, it's outside my expertise. And number two, I think that's a very hard thing to do. So I'm sorry, I can't help you with that question. All right, you guys, is there any more question? I actually have some questions here that that have been asked in previous webinars. Let's see if any of this interests you. So one of the questions is, are DIY living trusts valid? That was a really good question, So here's my answer. Yes, if it's done correctly. No, if it's not done correctly. Even the issue here is not whether it's DIY versus attorney. The issue here is quality versus garbage. Even a lot of living trusts created by attorneys still end up in probate. What you want to make sure that you have a quality DIY trust is to have checklists. Make sure it's why DIY trusts fail is if it's not state specific. You use a platform that's generic, so it's not state specific. So you didn't get it signed, notarized per your state's requirement, or it's not signed, witnessed, or notarized properly, or there's no backups to your key role. You only assigned one successor trustee, and then something happened that the successor trustee either just plain declined. I'm sorry, I didn't know, it's so stressful, I don't want to do this job, or he's incapacitated, and you don't have a backup. That's probate. Or it's not funded, you have an empty trust. These are the reasons trusts fail, whether it's DIY or attorney. If you ask yourself this question, are DIY living trusts valid? You should also ask, is my plane going to stay in the air? Do you know how you ensure your plane's going to stay in the air? Because you trust that these folks have a checklist and they've gone through the checklist to make sure that this plane's going to stay in the air. Checklist is your answer, is your key. That's why I provided a book of checklists. You want to go through the checklist to make sure that none of these things is your trust downfall. Let's see if I have another question here. Aside from the estate plan partner fee, what other fees should I expect? Okay, so the estate plan partner fee includes the wealth.com platform, all the document downloads. You can either download or print them or upload it to a digital vault, all the Zoom meetings. It does not include the print and ship. Wealth.com will print and ship the documents to you for $49. It's cheaper to send your documents to Kinko's or UPS to be printed. But please don't print your documents or don't ask wealth.com to print your documents if it's not finalized, because if you make any changes, wealth.com is going to charge you another $49 to print and ship your documents. $49, you can get a printer now with $49. So, but my fees does not cover that. It does not cover notary fees or witnessing fees, because most banks will notarize for free. And check with your bank. If your bank won't grab, people to be witnesses, you should bring your friends or your neighbors as witnesses. So it doesn't cover that. You have to, if you transfer your own deed, of your house, for the gentleman in California, I recommended paying $100 $50 to $200 to get a professional title company to do the transfer. But if you choose to transfer your own deed, when you file the deed at the county record office, there'll be a fee, a recording fee that's not covered. If you use a title company or attorney for the deeds, that's not covered. If you feel that you really will sleep better only if you have an attorney to review your document, that's not covered. Wealth.com does provide that kind of attorney review for $240. You can look it up you'll see it in Wealth.com. That's not covered. So I hope it's clear what's covered and what's not covered. What was another question that somebody asked? How long isn't it better to work? Okay, somebody had asked me, isn't it better to work with an attorney in my state? So if this is your first revocable living trust, I actually recommend a guided DIY, not for selfish reasons, okay? This is my second career. I love helping all of you because I was just shocked to find out that 2/3 of Americans don't have a plan. And I learned so much when I did this for myself, also when I trained as a certified estate planner. But whether you sign up or not does not determine if my kids eat tonight or not, okay? So this is not a self-serving opinion, but my opinion is that if this is your first revocable living trust, use a guided DIY. A guided DIY, doing it yourself with a guide, has 6 benefits. One is that you understand your plans. You're not just signing it. And you learn at your own pace with a guide. You're not going to feel intimidated in an attorney's office, feeling rushed, feeling like you have to look smart and make a quick decision. You have unlimited edits. 30 minutes after you make a decision, you can go edit, or 30 days or 30 months, you can go back on the platform. And you are getting attorney drafted state-specific documents. I would not be here today if these online platforms aren't so much more robust today. You also reduce the number one failure point. When you do it with an attorney, they do the first step. They create your trust documents, but you need to do the funding yourself, that second step, transferring all those titles, going to your bank and saying, hey, I want the designated beneficiary to be the trust and not my daughter. That you have to do yourself anyway. And number 6 is if after you do this, years later, your situations get more sophisticated, you can still walk into an attorney, in the future and say, I want to, create a new plan, but you would be a very different person walking into that attorney's office. You're not just somebody who knows nothing about estate planning. You would have so much experience. You would know what questions to ask. You'd be so much smarter about your plan. As a result, the plan you'll get with your attorney would also be, so much more robust. It would meet your needs so much better. So that's the question. Okay, I see all of you are still online, so I'll just keep going. How to transfer your house into your trust, okay? As I said, you have three options. One is an attorney or a title company. A title company would cost less than an attorney. It depends, again, on where you live, but it would be between $300 to $500 if you use an attorney. If you use a title company, it would be a little bit less. You could do it yourself with a quitclaim deed. I have a YouTube video that helps you determine if you're a target to do this yourself, because there are some situations where it's not advisable. Like I think it was Rich who has a property in California. California has very strict rules that has very severe consequences. You might not want to do it yourself. And another option is for Wealth.com. They do have a deed transfer service. It costs $175 plus the recording fee.